Alright, Assalamualaikum warahmatullahi wabarakatuh. My name is Ahmad Wafiq bin Khairul Azmi and my matrix number is 1222090 and I am from the group Wafiq and Associates. Today I will be presenting to you about the first issue of our assignment relating to arbitration. And as you guys know, arbitration is one of the alternative dispute resolution, or the short form is ADR. Okay, mine is the first issue. The first issue is about whether the law governing the main contract and the arbitration agreement can be determined based on the express choices made in the concession and development agreement, and what legal significance the selection of London as the seat of arbitration holds regarding the procedural law and the supervisory jurisdiction of courts. Okay, so for the next part, we will talk about the relevant provision that is related to arbitration. So, under the Arbitration Act 2005, Section 30, Clause 1 gives effect to the principle of party autonomy, meaning the parties are free to choose the law that governs their dispute. This can include transnational commercial principles, not just the law of a particular country. Next, Section 18, Clause 2 adopts the doctrine of separability. This means that the arbitration agreement is treated as separate from the main contract. So, even if the main contract is challenged, the arbitration agreement can still remain valid. And also, under Section 22, Clause 1, the parties may also choose the seat of arbitration. The seat is the legal home of the arbitration and determines the procedural law, or lex arbitri, as well as which courts have a supervisory jurisdiction. Okay, that is all for the relevant provision for this issue. And for case law, this principle was confirmed in Thai Lao Lignite Company Limited and Government of the Lao People's Democratic Republic, where the court in this case held that only the courts at the seat of the arbitration can set aside an arbitral award. Similarly, in the case of Naviera Amazonica Peruana against Compañía Internacional de Seguros del Perú, this case explained that the seat is different from the venue, as the seat refers to the legal location of the arbitration. And finally, if the parties do not expressly choose the law governing the arbitration agreement, the case of Sulamérica Cia Nacional de Seguros against Enesa Ingenharia states that the applicable law will usually be the law of the seat of arbitration. So, for the present case, to apply, in this case, Clause 26 expressly states that the main contract is governed by the transnational commercial law, international trade usages, and also general principles of the law. So, therefore, under Section 30, Clause 1 of the Arbitration Act 2005, the arbitral tribunal must respect the party's choice of law. Although Nusantara Resources argues that Malaysian law should apply because the project is located in Malaysia, this argument is unlikely to succeed because the parties deliberately chose transnational principles during negotiations. Okay, so for arbitration agreement, the parties expressly chose English law. Under the doctrine of separability, this choice is independent from the law governing the main contract, so it remains valid even though the main contract is governed by transnational principles. Okay, so in addition, the seat of arbitration is London. This means that English procedural law, or lex arbitri, and only the English courts have the authority to supervise the arbitration and set aside an award, even if there had been no express choice of English law. The case of Sulamerica Sia Nacional de Seguros against Enesa Ingenharia test would likely to lead the same result because the arbitration agreement has its closest connection to the law of the seat. So, therefore, the Malaysian High Court can only recognise and enforce the arbitral award under Section 38, and it cannot supervise or set aside the arbitration. Alright, last but not least, to conclude the first issue in the present case, in conclusion, the main contract is governed by transnational commercial principles, while the arbitration agreement is governed by the English law. Since London is the seat of arbitration, English procedural law applies. And only the English courts have the power to supervise the arbitration and set aside the award. So, therefore, Nusantara Resources is unlikely to succeed in arguing that Malaysian law should apply for, or that the Malaysian courts should supervise the arbitration. The Malaysian High Court's role is limited to recognizing and enforcing the foreign arbitral award. Okay, that's all from me. We will move on to our next presenter. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
My name is Akila Humera binti Shukri. My metric number is 1222072. For question B, the issue is whether mandatory Malaysian laws and public policy can override party autonomy in international arbitration. The central question here is whether the party's freedom to choose the governing law of their contract is absolute or whether it can be limited by mandatory domestic laws, especially when the subject matter of the contract is performed entirely within Malaysia. In this case, although global minor relies on transnational commercial law and English law as the governing framework, the mining operations were conducted wholly in Malaysia. This means the transaction is not purely international in effect, but is closely connected to Malaysian territory, resources, and regulatory control. Therefore, Malaysian mandatory laws and public policy cannot be ignored simply because the parties choose a foreign governing law. Moving on to the legal framework. The first and the most important principle is party autonomy. Party autonomy is a cornerstone of international arbitration. It allows contracting parties to freely choose the governing law, the arbitral seat, and the dispute resolution mechanism that will apply to their agreement. However, this principle is not absolute. It is well established that party autonomy is subject to mandatory rules of law and public policy limitation. Under Article 3.3 of Unidroit Principle, even if parties choose a governing law, they cannot exclude the application of mandatory rules that protect public interests. These include laws relating to environmental protection, labor rights, and public safety. In the Malaysian context, this is clearly reflected in several statutes. The Environmental Quality Act imposes strict obligations to protect the environment and prevent pollution, especially in industrial or mining activities. This reflects Malaysia's strong public interest in sustainable development. In addition, the Employment Act protects workers' rights, ensuring minimum standard of employment, while Section 12, Subsection 1 of the Passport Act prohibits the unlawful retention of employees' passports. These laws are clearly mandatory in nature and cannot be contracted out by private agreement. Next, in terms of application, Clause 26 of the agreement is particularly significant. It expressly requires compliance with Malaysian environmental, labour land and public safety laws. This clause strengthens the argument that the parties themselves acknowledge and accepted the application of Malaysian mandatory laws. Therefore, Global Miner cannot later argue that only foreign or transnational law applies while ignoring Malaysian statutory requirements. Additionally, the doctrine of supervening illegality is relevant here. The government's suspension of the mining license made it legally impossible for Nusantara Resources to continue operations. When performance of a contract becomes unlawful due to government action, the contract or its enforcement may be affected. This further supports the argument that Malaysian law must take precedence in regulating such activities. It is also important to note that the arbitral tribunal appears to have failed to properly consider the impact of mandatory Malaysian laws and public policy when making its decision. This omission is significant because arbitral awards that disregard mandatory legal requirements risk being inconsistent with the enforcing state's legal order. This position is supported by Malaysian case law. In Jan Denol, the High Court confirmed that Malaysian courts may refuse enforcement of an arbitral award if it is contrary to public policy. Similarly, in Far East Holdings, the court reaffirmed that while Malaysia strongly supports arbitration as a dispute resolution mechanism, this support does not extend to enforcing awards that violate fundamental principles of Malaysian public policy. These cases demonstrate a consistent judicial approach. Arbitration is respected, but it is not allowed to override core legal protection established under Malaysian law. In conclusion, while party autonomy remains a fundamental principle in international arbitration, it is not unlimited. It must yield to mandatory Malaysian laws and public policy considerations, especially in cases involving environmental protection, labour welfare and public interest regulation.
My name is Farah Najah binti Abdul Karim, matric number 1222108, so I will continue with question C. So the legal issue in this dispute is whether the London-based arbitral proceeding complied with the fundamental Malaysian principle of natural justice and the right to be heard, which are required before a foreign arbitral award can be recognized and enforced in Malaysia. Nusantara Resources argued that although the arbitration was conducted in London, several procedural decisions made by arbitral tribunal denied the company a fair opportunity to present its case. Specifically, the tribunal refused an adjournment request, conducted an important evidentiary hearing in Nusantara absence, and excluded relevant evidence relating to environment, labour and community issues. The question before Malaysian High Court is therefore whether this procedural defect were serious enough to justify refusing recognitions and enforcement of the foreign arbitral award under Arbitration Act 2005. So first, Section 20 provides that every party must be treated equally and be given a full and reasonable opportunity to present its case. This provision reflects the common law principle of audi alteram partem, which means that no person should be condemned without first being an opportunity to be heard. Second, Section 21 gives the arbitral tribunal discretions over procedural matters such as determining the admissibility, relevance and weight of evidence, as well as managing procedural timelines. However, this discretion is not unlimited. It must always be exercised consistently with the requirement of fairness and natural justice. Third, under Section 36, Clause 1, Paragraph A, Number 3, the Malaysian High Court may refuse recognition or enforcement of a foreign arbitral award if the party against whom the award is invoked proved that it was unable to present its case. In addition, Section 36, Clause 1, Paragraph B, Number 2, read together with Section 37, Clause 2, Paragraph B, Number 1, allows the court to refuse enforcement if recognizing the award would be contrary to Malaysian public policy, including situation where there has been a breach of natural justice. Finally, although Malaysia court generally adopts a policy of minimal judicial intervention in arbitration, the High Court in Taman Bandar Baru Masai Sdn Bhd and Dindings Corporation Sdn Bhd confirmed that court intervention is justified where procedural management result in patent injustice. So, applying this legal principle to the facts, Nusantara Resources has strong grounds to challenge enforcement of the award. First, the tribunal refused Nusantara request for an adjournment even though several key witnesses, including Malaysian environment officers and local community representatives, were temporarily unavailable due to ongoing regulatory investigations in Malaysia. These witnesses were highly relevant because the dispute involved compliance with environmental and labor obligations under the contract. By refusing the adjournment, the tribunal effectively prevented Nusantara from presenting an important part of its defense. Following the reasoning in Tawan Bandar Baru Masai, this amounted to procedural unfairness that resulted in patent injustice. Second, the tribunal proceeded with a crucial evidentiary hearing despite knowing that Nusantara required additional time to obtain important labor and environmental compliance documents. During this hearing, Global Miner introduced a new expert evidence on damages and causation, yet Nusantara was not given the opportunity to examine those reports, cross-examine the witness, or produce rebuttal evidence. This clearly violates Section 20, which guaranteed that every party a reasonable opportunity to present its case. Since these expert reports directly influenced the tribunal's final decision, Nusantara was effectively denied its right to be heard. As a result, this situation fell squarely within Section 36, Clause 1, Paragraph A, Number 3, because Nusantara was unable to properly present its case during arbitrations. Third, the tribunal excluded community impact, assessment, and human rights report on basis that the arbitration concerned only commercial issues. However, this reasoning is problematic because the underlying contract specifically required compliance with Malaysia environmental, labor, and public safety regulations. These reports were therefore directly relevant to the contractual obligations in dispute. By excluding them, the tribunal prevented Nusantara from relying on evidence that could have affected the tribunal findings on liability. Taken together, these procedural decisions demonstrate more than simple cases management. They show a pattern of unfair treatment and substantial prejudice Nusantara's ability to defend itself throughout the arbitrations. To conclude, the arbitration proceeding did not satisfy the Malaysia requirements of natural justice and right to be heard. The tribunal refusal to grant adjournment is its decision to conduct an important hearing in Nusantara's absence and its exclusions of relevant evidence collectively denied Nusantara a fair opportunity to present its defense. This action breached equal treatment required under Section 20 of the Arbitration Act 2005 and satisfied the grounds for refusing enforcement under Section 39, Clause 1, Paragraph A, Number 3 because Nusantara was unable to present its case. Furthermore, the serious breach of natural justice also made enforcement contrary to Malaysian public policy under Section 36, Clause 1, Paragraph B, Number 2, read together with Section 37, Clause 2, Paragraph B, Number 1. Therefore, Nusantara Resources has a strong legal ground to ask the Malaysian High Court to refuse recognition and enforcement of London Arbitral Award. That's all from me. Thank you.
The next issue is whether the Malaysian company Nusantara can successfully stop the Malaysian High Court from enforcing the foreign ruling against them, specifically when the London Tribunal crossed the line into legal unfairness by refusing to pause a trial when Nusantara's witnesses were unavailable, which holding a critical meeting without them and letting Global Miner submit new damage reports without giving Nusantara a chance to reply and ignore evidence about human rights and environmental pollution. So, Nusantara must prove that these actions are really serious enough to block the ruling under Section 39 of the Malaysian Arbitration Act and the New York Convention. Now we're moving on to rules and law. So the recognition and enforcement of foreign arbitral awards in Malaysia are governed by Section 38 and also Section 39 of the Arbitration Act 2005, which directly incorporate the international standards set out under the New York Convention 1958. So under Section 39, subsection 1, paragraph A, subparagraph 3 of the Arbitration Act 2005, the High Court may refuse enforcement if the applying parties provide proof that they were not given proper notice of the appointment of an arbitrator
or of the arbitral proceedings or was otherwise unable to present the party's case. Furthermore, under Section 39, subsection 1, paragraph B, subparagraph 2, mandates that enforcement may be refused if the High Court finds that the award is in conflict with the public policy of Malaysia. Section 37, subsection 2, paragraph B explicitly clarifies that a conflict with the public policy of Malaysia occurs where the fundamental breach of the rules of natural justice has taken place during the arbitral proceedings. So these statutory safeguards complements Section 20 of the Arbitration Act 2005, which sets out the mandatory procedural baseline that parties must be treated with equality and given a fair and reasonable opportunity to present their case. Moving on to the application, in referencing the current facts, Nusantara has a stable grounds to satisfy the high threshold required to resist enforcement under Section 39. Firstly, regarding Section 39, subsection 1, paragraph A, subparagraph 3 of the Arbitration Act 2005, Nusantara was effectively unable to present its case. So the tribunal rejected a legitimate request for an adjournment when key witnesses became unavailable due to official domestic regulatory proceedings in Malaysia. Proceeding with a critical evidentiary hearing in Nusantara's absence, while allowing Global Mining to introduce entirely new expert reports on causation and damages, which amounts to a textbook violation of procedural fairness, because of Nusantara was deprived of the right to cross-examine Global Mining's witnesses or submit responsive evidence to material calculations that directly influence the final award, its right to be heard was severely undermined. Secondly, regarding Section 39, subsection 1, paragraph B, subparagraph 2 of the Arbitration Act 2005, the final award directly conflicts with the Malaysian public policy through two distinct avenues. Per Section 37, subsection 2, paragraph B of the Arbitration Act 2005, the procedural issues highlighted above amount to severe breach out of the rules of natural justice, which automatically brings the award into conflict with domestic public policy. Financially and substantively, the tribunal also chose to limit and exclude vital evidence relating to forced community displacement, environmental contamination, and human rights assessments under the restrictive guise of a purely commercial arbitration. In Malaysia, statutory provisions regarding environmental protections, public welfare and labour integrity are mandatory hosted obligations that cannot be contracted away or ignored under transnational trade usages. By dismissing these issues, the award seeks to penalise Nusantara for complying with mandatory domestic enforcement interventions, thereby violating the fundamental public policy interests of Malaysia. So, in a conclusion, Nusantara Resources should be advised that it possesses strong legal grounds under Section 39, subsection 1, paragraph A, subparagraph 3, and Section 39, subsection 1, paragraph B, subparagraph 2 of the Arbitration Act 2005 to resist the recognition and enforcement of the foreign arbitral award in Malaysian High Court. So, the London Tribunal's refusal to grant a necessary adjournment, its handling of the ex parte evidentiary hearing, and its total exclusion of mandatory public law concerns constitute fatal procedural and substantive errors. Therefore, the Malaysian High Court is highly likely to refuse Global Miners enforcement application on the dual grounds of an inability to present a case and a direct conflict with Malaysian public policy.